Okay, this is an emergency fine print Friday on Michigan and the temporary restraining order they have filed against the Big Ten, trying to suspend the suspension that the Big Ten issued against head coach Jim Harbaugh, which prevented him from coaching last Saturday against Penn State. I was there. I'm a lifelong Michigan fan, but as a good attorney would do, you have to be able to arrive at a result you don't like. So we're going to go through the temporary restraining order and all the fine print in there. I'm going to explain to you what Michigan's going to argue, the things I like and don't like about the motion. And there are some things I do not like. I think they made some kind of lousy arguments that diluted their case. If you want to know more facts about this, you can look elsewhere. But again, very briefly, what happened was Michigan had a very low-level staffer who supposedly went to opponents' games in advance to watch them. And this guy was ex-military, very skilled at decoding signals, and he used that information to produce scouting reports on Michigan's opponents in advance. Crucially, there's no NCAA rule saying that you can't steal signs or look at those signs in advance. Those are all public information. They're holding up cards and stuff on the sidelines, kind of like baseball. There was no relaying information electronically or hacking into computer systems as far as we're aware. There was just this low-level staffer who was going to opponents' games to try to figure this stuff out in advance. And the reason that you're supposedly not allowed to do that, the NCAA put that rule in about the pre-scouting, I guess in the 90s, because the big schools like Michigan could send an army of people to opponents' games, but little schools like our town rival, Eastern Michigan, wouldn't have the resources to reciprocate those scouting reports. So the NCAA back 30-some years ago said, you can't do that. You can't send people to opponents' games. You can trade film. That's normal. Coaches trade coaches tape so they can understand and kind of prepare for the game. But you can't send people in advance. You can steal signs. And what the Big Ten did, they said that there's an NCAA investigation going on about this, and the Big Ten stepped in and said, we're not going to wait for the investigation to conclude. We're suspending Harbaugh now for the last 3 games of the season. The first one was last Saturday against Penn State. This weekend they play Maryland, and then the big one is next weekend at home against Ohio State. And Michigan really wants their coach to be there. So let's get into the temporary restraining order that Michigan filed. Okay, so here's the TRO. It's filed in state court in Washtenaw County. Nothing real sexy here. Table of contents, all normal stuff. Everything looks good here. I'm a little surprised at some of these secondary sources, these articles. Back when I litigated, you would typically attach these to the motion so the judge wouldn't have to look them up. So I thought that was a little peculiar, but I'm not familiar with Michigan civil procedure. In the introduction paragraph here, they're just kind of giving you the base of it, but this is one of the first sentences that stood out to me. The university is cooperating fully with the NCAA's investigation, and when that investigation concludes, the university will accept its share of responsibility under the rules. I love that word. That's the fine print, right? Its share of the responsibility. It's not saying we will accept responsibility. It's saying we'll accept our share of responsibility. And our argument, I'm sure, will be that we weren't responsible for shit. This staffer did it without our knowledge. And by the way, the Big Ten has said that they have no information showing that Harbaugh had knowledge of this staffer going to the games. So we don't know if he was involved yet, nor have they interviewed him. So we're saying we'll accept our share, but then the argument down the road is going to be our share is 0. We didn't do shit. Let us off the hook. So I like that to begin the motion. And I think that, Michigan starts pointing out the important things. The conference has not interviewed a single witness and has access to, at most, the NCAA's incomplete investigation. So how can you form a basis for a suspension when you don't have enough information? We're saying that the conference ignored the procedures. I'll explain that in a minute. Conference cites no evidence that the university continues to rely upon his scouting reports. And despite having no evidence whatsoever that Harbaugh knew about, directed, or tolerated the alleged wrongdoing. So this is important. We already fired the staffer. So whatever he was doing, whatever scouting reports he prepared are no longer impacting the team. And our other argument is we're already winning our games by 20, 30 points. It's not going to make a difference. So then at the end of the introduction, I thought this was weak. This is starting to get into the stuff I don't really like about this argument. Sportsmanship is an issue in this case. I don't really think courts care about sportsmanship. They've got bigger fish to fry. This isn't a real high priority for them. So I don't like how much we're leaning on the sportsmanship stuff. We need to be arguing there is a contract and they broke it. Okay, so statement of facts. this is important. University members' participation in the conference is governed by the Big Ten Handbook, which is incorporated into the organization's bylaws, okay? So what we're saying is all the Big Ten schools, we all signed a contract. We all said, we're going to do this by these rules. And part of those rules of the bylaws of the conference were the sportsmanship rules. And those sportsmanship rules say that there's a procedure you have to follow when you're going to issue a suspension or some type of penalty. And we're saying you didn't follow those. You might think to yourself, well, who cares? It's like sportsmanship bylaws, handbooks, rule books. It doesn't really care. What's the actual legal contract? Well, this is a legal contract. Those terms of the Big Ten sportsmanship policy are included into the contract that formed a legal binding contract, and the court, their job is to enforce that. Another part of our argument is those bylaws between the Big Ten also include the NCAA bylaws, and the NCAA bylaws say how investigations work and how the procedure works, and the conference agreed to comply completely and promptly with the NCAA's enforcement process. But as stands above, I think it's a little gray because it says, indeed, in complex cases like this, the NCAA is often the preferred organization to determine the facts and penalty because of its superior resources and experience. And then the usual process is to let the NCAA investigation complete first and for the conference to cooperate. So we're saying that those NCAA procedures are binding, but we're also admitting kind of that there's also times when the Big Ten can be in charge. And I don't really like how that plays out. And I think that that's going to be a big counter argument that the Big Ten will bring when the hearing is held for the actual restraining order. It's important to understand that the temporary restraining order is only between Michigan and the judge. The Big Ten won't be there. So we're going to get this restraining order, and then there's going to be a secondary hearing to see whether that restraining order is going to continue or not. And the Big Ten will bring their argument at that one. My prediction is that Michigan will get the temporary restraining order granted and will probably be lifted afterwards once the Big Ten has their part of the story heard. So if we scroll down, again, you see we keep hammering this point that the conference has not interviewed a single witness and has relied in substantial part on evidence that was merely described to the conference, in hearsay and articles and so forth. So now we get into the Big Ten sportsmanship policy. The sportsmanship policy is part of the Big Ten handbook. The Big Ten handbook is incorporated into the bylaws of the conference. The bylaws are a binding contract among all conference members. So therefore, the Big Ten commissioner has to follow the sportsmanship policy when he's handing out a suspension, and he didn't do this. That's our argument. It says that the policy authorizes a commissioner to impose disciplinary action on only two specifically delineated categories of respondents. First, the commissioner may hold individually accountable, a person associated with an institution like Harbaugh, if that person is found to have committed an offensive action. And we already know that the Big Ten has said, we haven't interviewed Harbaugh, we have no information showing that he knew about this. So our argument is, how can you say that you can suspend him when you don't have any information showing that he committed an offensive action? And then secondly, the commissioner may hold accountable an institution that is responsible for the person who committed an offensive action. Again, we have no information showing that Harbaugh knew about this or that he was involved in it or sanctioned it, so nor have you interviewed him. So how can you issue a penalty to university when there's no offensive action that's been proved? So these are good arguments. That's like the basis. And now we're going to get into what a temporary restraining order is. So a temporary restraining order, you may have heard about this more in like family law, domestic violence cases, trying to keep somebody away from you, stalking. Well, they also apply for businesses and any like immediate wrongdoing. You can go to court and say, look, there's an immediate problem. We have to do this now. It cannot wait. Please issue an order restraining this person, this institution, this whatever, from committing whatever action that we're afraid of. And there are factors involved in that, things that the courts have to consider. So let's get into those. First of all, the object of immediate injunctive relief, a temporary restraining order, is to preserve the status quo. That's a good legal argument to start with. The point is, we're going to go back to the way we were doing things, and we're going to fix it later because it's going to be fair for everybody involved, okay? One thing you have to prove is irreparable injury. We'll get into that. This is a good point. Under Michigan law, a temporary restraining order may issue if you prove that immediate and irreparable injury, loss, or damage will result to the applicant from delay required to effect notice. So one of the things we're mad about, Michigan, is You had all week to suspend Harbaugh, and you issued the suspension on Friday, like less than a day before the game, on like a federal Veterans Day holiday, the next day being a Saturday. We had no time to do this. And I think that's probably why the case restraining order was not decided on last weekend. Another note about that, the case was initially assigned to apparently a judge who is an adjunct professor at Michigan's law school. I speculate that judge had to recuse himself because there's a conflict of interest there. He's getting paid by the law school of the institution that is associated with the athletic department that's subject to this suspension. So I think that judge may have recused himself, and there wasn't enough time to get it reassigned to another judge who was on duty on a Saturday during a holiday weekend to get it heard. And that's why the hearing, rather than being decided last Friday, will wait and will be heard next Friday before the Maryland game. Okay, so scrolling down, this is the important part. So this is what you have to prove to get a preliminary injunction. That's the same thing as a temporary restraining order. There are 4 factors, okay? Factors are different than elements. Factors are like, we're going to consider these 4 things and kind of weigh them. Sometimes you hear about elements in law. You have to prove 1, 2, 3, 4, and 5, or 1 and 2 or 3 plus 4 or 5. So it's not you have to require all of these. We're going to submit evidence in favor of each of those 4 factors and argue why, in the totality of those circumstances and facts, why the temporary restraining order should be granted. Now, I will say that you definitely have to show irreparable harm. That's definitely a requirement. There are a couple other ones that I'll get to in a second that are a little less important factors, but they're not logical. This is not if then. This is look at all of these 4 and kind of weigh them all together and then decide. So the 4 things you have to prove are the likelihood of the party seeking the injunction will prevail on the merits. This means you have to have a good legal argument, okay? Breach of contract is usually a pretty good legal argument, okay? You can't bring a bullshit argument and get a temporary restraining order. You have to show a pretty good argument so the judge thinks that it's legitimate. You have to show irreparable harm. Your argument there is that the games can't be replayed. We need Harbaugh now. The third one, these last 2 are a little bit less important. We have to show that the risk that our party, Michigan, seeking the injunction will be harmed more by not getting the injunction than the Big Ten maintaining their suspension of Harbaugh. And then the 4th one, harm to the public's interest if the injunction is issued. This one isn't going to play in very much here. So let's really just focus on the first 2. We'll talk about the 3rd and 4th briefly. Of course, you say always all 4 factors weigh heavily in favor of Michigan. Okay, yeah, bullshit. You're just making your best argument. Okay. The first argument's good. Michigan is highly likely to succeed on its breach of contract claim. This is a good argument. You always lead with your best argument. My complaint about this motion is that the next 4 arguments are really weak, and I think they really dilute the best argument that they have. It starts to sound more bullshit when you keep giving bad reasons after one really good one. Now, typically in litigation, you try to bring as many as you can, but I remember very, very vividly in my civil procedure class, first semester of law school, my professor, Lisa Dolak, said, when will these litigators understand that not to try to cram 12 arguments into a brief, just pick your best 3, 4, or 5 and stick with those? Because if you can't win one of those, the other 7 or 8 that you're bringing aren't going to hold any water either. So don't waste our time. Don't dilute your argument with those. Just stick to the good stuff. And I think that that's a mistake Michigan made in this motion, although I still think it'll probably get granted. So we explained the breach of contract. The bylaws are between all the conference members. The sportsmanship policy is part of those bylaws. The procedure for suspensions is part of that sportsmanship policy. The conference did not follow those procedures. The handbook unambiguously requires the process for alleged major rule violations in the form of notice through investigations, deliberation, and decision. The commissioner made no attempt to abide by these due process protections. And I think we're right. There was no investigation. There was no interviews. There's no facts discovered. They're just going off hearsay. And I think that's a pretty darn good argument we're making there. Another thing we say is, we cite this case that says the Michigan courts must give effect to every word in a contract. Okay, this is important because what we're arguing is if the commissioner can just like willy-nilly issue suspensions like this, then the sportsmanship policy really, it doesn't mean anything. So it has to mean something. We have to draw the line somewhere, and this suspension is beyond that line. It's a decent little argument in there. because otherwise the words in the contract wouldn't have any meaning. I don't like this argument. This is the plain language of the contract is confirmed by conference precedent. The court doesn't care about conference precedent. Precedent isn't particularly interesting. It might show that the Big Ten is being a little unfair, but the precedent is not binding. Commissioner power is typically very broad. You can think back to the Tom Brady case with Deflategate and his suspension and Roger Goodell. He took Goodell to court and the court said, look, the commissioner can pretty much do whatever he wants. And I think that's kind of the case here. And that will be the Big Ten's argument when the restraining order, not the temporary restraining order, but the actual restraining order is heard later on. This is a tough argument to make right here. Even if the commissioner were permitted to sanction the university under the sportsmanship policy, which it can't, the commissioner is still required to conduct a reasonable good faith investigation and to allow us an opportunity to respond. It's hard to make this argument to say, even if we're wrong, we're still right. But this is how you do it. This is a nice little, it's hard to make alternative arguments without sounding like you're full of crap. But this is a pretty nicely done. We also say the conference breached their contract by targeting Harbaugh, which exceeds their authority under the sportsmanship policy. It only applies to individuals who committed an offensive action. We don't have any evidence that Harbaugh committed it, so you can't suspend him. Now we get into the weak arguments. I know you got to bring probably more than just one with the breach of contract, but all of these other ones I think are really weak. The conference has violated the implied covenant of good faith and fair dealing. Every contract has the assumption that you're going to act in good faith and deal with the other side fairly. It's very, very hard to prove that somebody acted in bad faith in contract. This argument doesn't hold water, and I think it starts to dilute the strong breach of contract argument. The next one, promissory estoppel. This is legal terms for, in fairness, this suspension shouldn't be allowed. Also very difficult to argue, in my opinion. There's no real possibility you're going to lose a breach of contract argument, but win the promissory estoppel or the good faith fair dealing arguments. It's okay to spend a little bit of time on them, but I don't think that this is really good. We're saying that we relied on promises that the Big Ten made to us, et cetera, et cetera. I just think it's pretty darn weak. This one is another weak one. We say that the commissioner owes a fiduciary duty to the university. You can't treat Harbaugh unfairly as a commissioner. You owe the university and this conference member a fiduciary duty to act in their best interest. Okay, all right, fine. But what about the other 15 conference members? Don't they have anything to say about it? So this argument is clearly rather hollow, and I really didn't like it. I wouldn't have even brought that one in personally. The last one is a little bit better. I think they should have moved this last one up. The fifth argument is Harbaugh can sue for intentional interference with his employment contract. This is basically saying you knew Harbaugh had this contract and they're intentionally going in there to screw him over. They've got seeking him out and targeting him. Look, maybe, but unless there's a smoking gun email of Petitti saying, I really want to screw this Harbaugh guy over and get him out of the conference, you're not going to win this argument. So that's kind of how we approach this. We cited this case, which I looked up briefly, saying that publicity places a plaintiff in a false light in the public eye, basically by giving Harbaugh a bad reputation, a bad look in the public is one type of invasion of privacy sufficient to support a claim. Okay, but that case had to do with a HIPAA violation and a patient's identity being disclosed on social media by somebody working in the healthcare space, really not related at all to this. I know that there's not going to be a lot of cases directly on head coach suspensions. Really tough to find a good case law on that. So you have to do your best. And, I know they've got their clerks and everybody digging into laws and cases, trying to find something that works here. You're kind of putting a square peg into a round hole. You got to do your best argument you can. But, some of the citations I pulled for this, I'll show you another one in a minute. It just really doesn't hold water. Okay, so the second factor we have to prove is irreparable harm. I do not like one bit how Michigan made this argument. Give a little bit of an intro, and then we say, this is just word salad. It's impossible to quantify the entirety of this significant harm that will befall the university absent injunctive relief. But there can be no doubt that the university, its students, and its community will suffer greatly. The university itself, and particularly its athletics program, will endure significant and lasting reputational injury if the conference is permitted to impose a sanction in advance of a full and fair investigation. The university prides itself on fairness and integrity. Oh, woe is me, your community, your students. Oh my gosh, this is so unfair. Look at this next couple paragraphs down. Way better argument that they should have led with. So again, this is the second paragraph in this part of the argument, and we have to scroll an entire page or so down to get to the part that I like. More fundamentally, the harm to the university's student athletes would be irreversible. Now 9-0 in the season, it's undisputed that the team is in contention for the national championship. The seniors, this might be their last conference games against a rival. This is what you should have led with. We're 9-0. We're playing Penn State tomorrow. We need our head coach. What the hell are we waiting for? Get this done. Don't start with the irreparable harm to our students and our staff and our community. Don't lead with that. We have a football team. We need our coach to lead the team tomorrow against a ranked number 10, 12 team in Penn State, a damn good opponent. Why is this so buried so far down this argument? I don't like it. I still think we'll win, but I just don't like the way the structure of this argument came out. I like this sentence a lot too. Suspension of Coach Harbaugh deep into the team season would irreparably harm this university's chances of success. This is not merely conjecture. Yes, it is. Yes, it is. It's completely conjecture. We're completely speculating that Harbaugh is going to have a major impact on the outcome of this game. Again, Harbaugh was absent the first 3 games of the season. He wasn't there on Saturday against Penn State on the road against the best team opponent we've played so far, and we still won by 2 scores. So yes, it is still conjecture. This is a nice argument a page down. While Penn State, Maryland, and Ohio State will finish out the season under the leadership of the head coaches, the university will be forced to change course on the eve of critical games. Now, counterpoint, other conference members might say, okay, well, when we found out that Michigan was pre-scouting us, we had to change our signs, right before the game, so that wasn't fair to us either. Okay, the third factor, again, we're kind of weighing these as best we can, is the balance of equity. So we're saying it's more fair to not suspend Harbaugh than it is to suspend him. That's what we're arguing here. This is a good argument. No additional misconduct of the type the conference has alleged is ongoing. We suspended Stallions within 2 days of learning about this. And the conference has not claimed that any other member of the coaching staff has been involved in in-person scouting. I like how they say in-person scouting and not sign stealing. This is a scouting issue, not sign stealing. Sign stealing is legal. In-person scouting apparently is not an archaic rule, but hey, it's a rule. There is no colorable claim that the university posed any harm to its competitors. That's a great argument. There is no more, Stallions isn't on the staff anymore. We stopped the bleeding. So why do we have to suspend Harbaugh now when you haven't interviewed him? You haven't let the NCAA complete their investigation. It's not fair to us. And here we are again, we're pointing out sign stealing, the practice of decoding opponents' play signals, is legal under NCAA and conference rules. The issue here was about the in-person nature of the signal recording. I think this is, Michigan should be hammering, every Michigan fan should be hammering this. This isn't sign stealing, this is pre-scouting. And when you say this pre-scouting, geez, it really doesn't sound that bad, does it? Everybody pre-scouts, everybody sign steals, sign stealing is legal. Like, I really don't get the big deal here. So the terminology here is clearly crafted against us. They're out to get us, Michigan fans. They're coming out to get us. So keep going down. It can only benefit the conference to conduct a thorough investigation to ensure any punishment is warranted. Good argument. And then the last one, this is the last factor, the public interest who would be served by an injunction. This is the right way to start this argument. Is basic principle of contract law that enforcing a contract by its plain terms is in the public interest. We have the bylaws, the sportsmanship policy is part of those bylaws. That's a binding contract. The public has an interest in enforcing the contract as stated. As the words on the page say, I like that argument. That's the way to do this one. Don't get into, fairness and public policy and how do people feel, blah, blah, blah. No. What do the words on the page say, and are you enforcing them or not? But still, I'd say that the public interest argument here isn't super important. Notice the typo here, big law firm getting paid big bucks. They said the 2013, the viewership for the championship game between Georgia and TCU. Nope, that was last year, 2023, not 2013. Fans have a vested interest in seeing the most deserving team win the title. Weak argument, don't really care. So conclusion, all right? So looking at this in the whole, so the 4 factors again, you have to show that there's a likelihood of succeeding on the merits, saying that you have a good legal argument. You have to show irreparable harm. You have to show the balance weighs in our favor. It's more fair to stop the suspension than to continue it, and then the public policy, okay? So quick summary, likelihood of succeeding on the merits. We have conference bylaws. Everybody agreed to them. This is a binding contract. The Big Ten rule book is part of that contract. The Big Ten sportsmanship policy is part of those rules in the rule book. Let's take a quick look at those very briefly. It says factors that may be considered, okay? may be considered when deciding upon disciplinary action. A, general nature, severity of defensive action. Apparently this one's a little bit more on the serious side because it allegedly affected the outcome of games and stuff, as opposed to just being mean on social media or, abusing an official or something, or yelling or screaming or being unsportsmanlike. The second one is definitely in our favor. Any injury or damage that results directly from the offensive action. Our argument is there's no evidence that this had anything to do, that this impacted the outcome of games. Again, it says directly related. Okay, you cannot show that it's directly related. You can show that, yes, it was something involved in the staff, but you can't show that it had a direct tie to the outcome of the games. And I think that's something that weighs in our favor for this argument. The manner in which offensive action fits within the context of the rules and the sport at issue, not very good. I mean, our argument there would be that, well, it's pre-scouting. Everybody looks at game tape. Everybody's holding up their signs on the sideline. It's public information, and it's within the context to look at them. Well, they're going to say, well, the NCAA rule says you can't do this, and you're therefore in violation. Fourth, any action imposed in accordance with the applicable rules of the game, not relevant. It didn't happen during gameplay. Fifth, the response of or any action taken by the involved member institution. We had fired Stallions pretty much immediately after suspending him, so we took care of that. And then I thought this is interesting. Response of any other action taken by another entity that might have jurisdiction over the offensive action. And it says, like, for example, law enforcement. I'm like, well, what about the NCAA? What about the NCAA bylaws that you said that you'd abide by? So I was kind of surprised that that wasn't listed there. And any prior offensive action as contemplated within this policy. Maybe they'll say, well, look, we suspended Harbaugh the first 3 games of this season. Maybe that's a prior offensive action. And then very briefly, the commissioner's discretion. Again, the commissioner's discretion is a very broad power typically. I don't know exactly how it's stated in the Big Ten bylaws, but using the NFL and Tom Brady as an example, when they suspended Brady without basically very good evidence that he was doing anything intentionally, Brady took him to court and said, you got to do better than this. And the court said, look, the words on the page say the commissioner can pretty much do whatever the hell he wants, so stuff it. And that's what the Big Ten is going to argue too. They're going to say, our rules say that the commissioner can pretty much do whatever he wants. There's no binding precedent here. We think this is fair. Beat it, Michigan. We don't really care about your argument. And last point here, any involved institution or individual at risk of disciplinary action shall be provided an opportunity, which may be waived, to offer his or her position as to whether an offensive action occurred. This doesn't say that there has to be a hearing. It doesn't say there has to be a hearing. Big Ten gave notice of maybe a suspension early last week, and Michigan replied, sent them a letter in response. Is that a response? Does that count? Or does there have to be a hearing here? I think the Big Ten is going to argue, well, yeah, we did give you an opportunity. You sent us a letter in response, and we didn't find it meritful, and we issued a suspension anyways. So what I think is going to happen here, I think the restraining order will be granted. So the suspension will be suspended. I did read an interesting argument online asking why Michigan filed this in Washtenaw County, in Michigan. They said that maybe they should have filed it in Illinois or Maryland or Pennsylvania, because those jurisdictions are the ones in which you need to actually enforce the restraining order to allow Coach Harbaugh to play. And they speculated that the judge might toss the case because it's not in the right jurisdiction. That could be the case. I think that the temporary restraining order will be granted. I think that it's fair for Michigan to bring it in state court in Michigan. That's where they were wrong. That's where the harm was caused. Illinois isn't that far away. The Big Ten has resources to travel to Detroit, Ann Arbor area to defend their case. So decent argument there. That is a possibility that the judge just says this is brought in the wrong courthouse. He should have brought this in Illinois where the Big Ten headquarters are. So we'll see how that goes. But I think the temporary restraining will be granted. I think that there is a breach of contract, or I think there's a good argument that there's a breach of contract. I think that Michigan has showed that there is a likelihood of succeeding on its merits, given the fact that only their side of the argument has been heard so far. I looked up the Michigan Civil Procedure Rules. I think they said that a temporary restraining order will last no longer than 14 days. So if it were granted this coming Friday, that would last long enough for Coach Harbaugh to get through the Ohio State game. However, following hearing on the permanent restraining order were heard in the week before the Big Ten championship game. It could be that his suspension applies to the Big Ten championship game and maybe even college football playoff if we make it that far, or if we make it to the Big Ten title game also. That's yet to be determined. Knock on wood about that one. We still have to beat the Buckeyes, and boy, I hope we do. I think that this will be granted. Those are arguments for and against. I hope you enjoyed this. Happy Fine Print Friday, and go blue. Stay tuned because I'll cover the permanent injunction next if this one's granted. Thanks.